My name is Chu Machinye, and I am your family lawyer. Let's look at the family of Ukeje, whose case was decided in 2014 by the Supreme Court. There, the Supreme Court said that a child who was born out of wedlock was entitled to inherit from the father's estate. The court, by doing so, invalidated the grant made to the deceased widow who had suppressed the paternity of this child. In other words, the man had a child, the wife went and applied, because that child wasn't hers. She didn't mention the child. He was born out of wedlock, but the court said he too should be part of that estate. The exclusion of customary or statutory beneficiaries can nullify the grant of letters of administration. That's essentially what this case decided. When an applicant fails to seek or obtain the necessary consent of other equally or lawfully entitled persons, such as other children of a deceased person who did not live with him, the application may be successfully challenged insofar as he had acknowledged that those were his legitimate children before he died. So wherever the children are, you have to inform them. They need to know and be part of what you are doing regarding their father's estates. The process of obtaining letters of administration is governed by principles of honesty, transparency, and equity. And any deviation by way of fraud, by way of misrepresentation, concealment, or exclusion undermines the justice system and provides sufficient grounds for legal redress. The courts in Nigeria have demonstrated increasing willingness to invalidate flawed grants and protect the inheritance rights of all qualified beneficiaries. Whether these beneficiaries come under statutory claims or customary or under Islamic law, they are entitled. Therefore, any party who suspects that a grant was wrongfully obtained should act swiftly by instituting a legal challenge in accordance with the relevant probate rules and procedure. We've spoken so much about why the application for or the grant of letters of administration may be challenged. Now, let me explain to you in simple terms the procedure for challenging an application for letters of administration. You know, I mentioned that when an application is made, the court publishes for average of 21 days. So if you're an affected person and you feel that what is going on is not acceptable to you, your first step would be to issue what is called a caveat. You go to the probate registry and say, I want to object to this pending application. And when you go there, they would naturally give you a form which you would have to fill out. And this process is governed by the administration of estate law and part of the High Court Civil Procedure rules. When you bring a challenge to an application, what you are saying is that you have an interest in the deceased estate and you are typically a spouse or a child or a sibling or some other person that is entitled to benefit under intestate succession. You don't just wake up because you're a friend of the deceased and you go there and say, I want to object to this application. You have no right to do so. As I said, the first procedural step is to enter a caveat at the probate registry of the High Court where the application is pending. A caveat is a formal notice to the court to prevent the grant of the letters of administration until the issues raised by the challenger are resolved. When the caveat is issued, notice is typically given to the person who had applied for letters of administration. He, in turn, may then file an affidavit to say, well, I don't agree. And when he has done so, the person who issued the caveat may counter with a further affidavit. And then the probate registry, and the probate registrar, in fact, will try to resolve these issues that are before him. Where all of this fail and the issues between the caveator and the applicant cannot be resolved, then the person who issued the caveat will typically have to commence a probate action in the High Court to ask the court to determine whether or not that application should go forward or whether the person actually does have an interest. When that happens, the application will remain in abeyance until the matter is resolved by the High Court. When it is resolved, it is usually resolved either in favor of issuance of the letters of administration or upholding of the objection. Let me make something clear, which is very important at this point. Challenging an application for letters of administration involves procedural diligence and timely filing of caveats and affidavits. Almost everything involving this is timed, so you must follow those timelines. The courts are empowered to protect the rights of legitimate beneficiaries and to revoke any grant secured through fraud, suppression, or exclusion. But the early legal intervention is crucial in safeguarding inheritance rights. If you or someone you know suspects foul play regarding the estate of a deceased relation, call a family lawyer. Do it now. Or visit our website for guidance. When an application for the issuance of letters of administration is successful, it confers legal authority to manage and distribute the estate of a deceased person who died without making a will. This, of course, has consequences that are significant, both for the administrator himself and for all the interested persons in the estate of the deceased. And this usually will include the heirs, the dependents, the creditors, and other third parties that may be affected. Usually, a successful application will vest legal authority upon the grantee of the letters of administration, who becomes now the legal representative of the deceased estate. And although the title of the property vests in the beneficiaries, either under customary or statutory law, the succession rules and the legal title to manage and distribute this estate is temporarily vested in the administrator. Let me explain. When you get an application for letters of administration, you do not become the inheritor. It does not mean that the property is now yours. It means that you have a right to identify those who are entitled to it and ensure that they get them. And where debts are owed, you identify the debtors and ensure that with the full participation of the beneficiaries, the debts are paid and that transparently they can see what is left and then it's shared amongst them. Ordinarily, a grantee of letters of administration is immune to prosecution for just and lawful acts. But he must act within the ambits of the law. Once he exceeds them or acts mala fides, in bad faith, then that protection is removed and he will be liable for his actions. If you mismanage the estate, for instance, or act fraudulently in dealing with that estate, surely the law will hold you accountable and you may be removed as an administrator if you breach these fiduciary duties. And you may be asked to refund monies that you can't account for or that you may have stolen. Now, what this, of course, means is that any person at all who claims to be entitled to inherit must then pass through this administrator to be able to take benefit from that estate. You cannot transact through another person, but through the administrator to exert or take your rights. But where he denies those rights, of course, you have a right to go to court. This grant of letters of administration helps bring finality and closure to an estate because everything is put together on a table, and where the administrator is acting in good faith, it triggers the beginning of the end of winding up of a person's legacy, because everything is put on the table and is distributed. Where everybody seems satisfied, that's the end of the story. The estate is administered, and the administrator files final accounts and makes returns to the registrar of probate. I will bring you the facts of what happened to the Okoye family When Chief Okoye died, uh, his son went to court to challenge the letters of administration that was granted to his stepmother, who ostensibly was not married to his father at the time of his death. He contended that the grant was obtained without his knowledge and that he, being a biological son, had a superior right to administer his father's estate. The court had to determine whether the probate registrar was right in granting these letters of administration to this stepmother without notifying or obtaining the consent of Chief Okoye's son, who is obviously a person with a superior interest in the estate. The Court of Appeal decided that the Okoye's son, who is a biological child of Chief Okoye, had a superior interest in the estate compared to his stepmother, who apparently at the time in question was not married at all relevant times, was not married to Chief Okoye. The court emphasized that the probate registry should have ensured that all persons with potential interests in the estate were notified before granting letters of administration. I have been emphasizing not married because if she was legally married to the deceased at the point of death, she would be first in order of priority. Consequently, the court set aside the grant issued to Mrs. Okoye and ordered that the administration of the estate be revisited, ensuring that all interested parties are given an opportunity to be heard before a fresh letters of administration will be granted. You can imagine how long this took and what would have happened to the estate. And those in school that needed help may not have gotten that help. Letters of administration are usually granted to the persons with the highest legal interest in the estate, who are usually the closest person to the person who died. And when you fail to involve them, the letters of administration you obtained will be useless. In another matter, which involved a dispute over the administration of the estate of late Mr. Oyeyemi, his children challenged the grant of letters of administration that was issued to an interloper who claimed to be a close associate of Mr. Oyeyemi. Close associate. Imagine the temerity. The children argued that this man had no familial ties to their father and that the grant was obtained fraudulently without their knowledge or consent. Without being a judge, with these facts, I even agree that it was obtained fraudulently. The court didn't have too much problem with dealing with the issues that arose, which included the legal standing of this interloper to apply for letters of administration without the knowledge and consent of the deceased children. Of course, that grant was invalidated because the man who took advantage and applied for letters of administration lacked the requisite legal standing to apply for the letters of administration. He was neither a blood relative nor a legal representative, an attorney of the deceased. In deciding this matter, the court emphasized that the children of the deceased, being direct heirs, had a superior claim to administer the estate. And so the grant issued to this man was declared null and void and of no consequence. What this means is that only individuals with legitimate legal interest, such as direct heirs or duly appointed representatives, are entitled to apply for letters of administration. Let me emphasize that the failure to notify or obtain consent from rightful heirs before applying for or grant of letters of administration renders such application or grant invalid. Individuals without legitimate legal standing, such as non-relatives or associates, cannot validly obtain letters of administration over an estate. If they do, the court will nullify them if they are challenged. Now, my final word on today's episode. Ideally, we should all make our wills whilst we still can. Even if we do not think that we own much, or even if we have faith that will make the biblical 120 years, make a will whilst you still can. Do it now. Typically, the average Nigerian man or woman does not make a will, often leaving spouses and children in quandary upon their demise. It has been reported that more than 78% of people in Nigeria die without making a will. When your spouse or parents or other close relation dies without making a will, endeavor, soon after the tears have dried up, to summon a family meeting to agree on who should represent the estate. And as soon as this is resolved, such persons should immediately apply for letters of administration. Today, we've taken time to walk you through what letters of administration are, who can apply, how they work, what happens when things go wrong, and how the law protects the legitimate interests of all legitimate heirs and punishes those who try to outsmart the system. If you are dealing with a loved one's estate, please seek professional legal advice and tread carefully. Do not do unto others what you would not like to be done unto you. You know why? Just like the person whose death has put you in a position of advantage, in a position of trust to handle this estate, you too will die someday. And someone will play the role you are not called upon by providence to play. What goes around comes around, they say. Please join me next Saturday on Your Family Lawyer, when we will continue to guide you through the law that protects your legacy. It is called family law. Don't forget to click the subscribe button and to turn on your notification bells for more interesting and helpful episodes. For legal consultations or advice, please call us today by dialing the number on your screen. Until next Saturday, please stay informed and be empowered. And always, always be good to your family. My name is Chuma Chinye, and I am your family lawyer.